Morning, sir. Good morning, sir.
Good morning.
Good morning, everyone. Sir, I may introduce to the with a kind privilege. I have the honor to introduce our panelists to the uh, interview candidate. I may first, with great honor and privilege, introduce to Sri Gadar Panda sir. Sir has been a retired district judge having 30 years of experience in the legal fraternity, and he was also the legal advisor to the legal state vigilance department. Also, he is also teaching and imbibing the students with experience at least for 10 years and more. He was also a uh, examiner in the chief examiner committee of Odisha Judicial Service. So thank you, sir, to honor with your gracious presence in this mock interview. Uh, Now I may also introduce our second panelist, Sir Dr. Pallab Das, Dean of Centurion School of Law. Sir was also an ex-judicial officer. So I thank you for on behalf of the Initio Law Institute for joining us today. Uh, uh, I may request Sir Gadar Panda sir to start the mock interview. Thank you, sir.
Yes, good morning, Anshuman. You are
Good
from which
morning, sir.
place?
Sir, I belong to Rath, sir.
You are residing at Rath.
Sir, currently I'm residing at Bhubaneswar. I belong to Rath,
Yes.
sir.
Can you say what is the difference between residence and domicile?
Exactly, sir. Sir, residence is the place where we are currently residing or we are residing for a certain amount of time. Whereas domicile is the place where we intend to stay there for a longer period of time or permanently, sir.
What were your optional subjects of law in judicial service examination?
Sir, this year my optional subjects were torts and IPC, law of property, and personal law, sir.
What is the difference between tort and a contract?
Sir, contract involves the parties. The contract involves a relation in between, or the contract revolves around the parties only. Whereas tort is related to the realm. Tort always involves compensation, whereas contract involves the privity of the consideration, and also in relation whatever the contract has been prescribed. Into that only it involves the amounts. And
If that,
contract involves liquidated damages, whereas dot involves unliquidated damages.
what is the difference between liquidated damages and unliquidated damages?
So liquidated damages is where you already know the amount which is involved in it, whereas unliquidated damages no amount has been specified.
Can a private can a private person sue the government for trustee liability?
Exactly, sir. In under vicarious liability, a private person can sue a government.
Why vicarious? Yes, vicarious. Is there any exception to that? In a case where there is an exception, the government will not pay the liable under tort.
Yes, sir. Where the government is, where the person is doing uh, distinct services, a sovereign function, while doing sovereign function, if any discrepancies happen, then in that case, the liability will not be imposed, sir.
That's okay. Who is a child?
Sorry, sir, I couldn't hear you, sir.
Who is a child?
Child. Child is basically a person below 12 years, which is to be considered in some cases, but I cannot exactly remember the provisions where it is mentioned about child, sir.
If somewhere it has been defined who is a child, if any law, anywhere in a law that which defines a child,
I'm not aware of it, sir.
a child of 11 years of old committed murder
Yes, sir.
is facing trial in a juvenile court, whether he is liable.
Sir, as per Section 84 of IPC, it is to be checked whether he has the idea or he has the notion about his conduct of the act or his consequences of the act. If he's mentally in the state to understand the consequences, then he can be made liable for that.
X instigated a child to put poison in the food of Z with an intention to kill him. Whether X committed an offense.
Ex instigated, yes, sir. This is basically he has used that particular child to commit an murder, sir. So he has committed the offense of murder.
That's committed the offense of murder, simply to instigated for committing murder. Murder has not been committed.
Sir, if child is unknown about his consequences and he cannot apply the mind, for example, if you are using the concept of Dolin Capex, where the child is basically 7 years of age, less than that, and he has been used as a prop to commit a crime, then in that case the person will be liable, sir. It will be same in effect that he has done by himself, sir. That he has put the poison himself, sir.
A police sub-inspector came to a village to arrest Mr. Z. Why, knowing that Z, that person is not Z, identified L as Z, and that police officer arrested that person. What offense the person who identified committed?
Sir, since it is a bona fide mistake, then it will be considered as a mistake and it will come under the purview of general exception, sir.
My question is, intentionally he identified. It's
Okay.
not a bona fide mistake.
Sir, then when he is intentionally identifying that person as another person, then he has exceeded his, sir, I'm not able to tell exact offense about it.
A person exceeding his right of private defense killed somebody. What offense he committed?
Sir, it is culpable homicide not amounting to murder, as it is coming under the special exception under the section 300, sir.
What is a representative suit?
So, a representative suit is given under Order 1, Rule 8, where one person may be from side of defendant or from the side of plaintiff is representing more persons their equal interest, and where he can file on behalf of those persons.
Is there any procedure, special procedure for that?
Sir, I am not able to recollect, sir.
What is interpreter suit?
Sir, interpreter suit is given under Order 33 of Civil Procedure Code, where basically the plaintiff do not have any claim in regarding to the matter, but he has basically he wants to submit that particular amount to the defendants who with those two defendants fighting amongst each other. So he submits that particular amount with a request to the court that to provide them to consider those two defendants' request and then proceed with the judgment. And also he claims for the cost that has been beared in that particular suit, sir.
Can a suit be filed against the government dispensing notice under section 80 of the CPC?
Yes, sir, it can be filed, sir.
In which case?
Sir, sorry, yes, sir, I'm not able to recollect.
What is the difference between extortion and theft?
So extortion, basically where there is a threat or fear has been induced in a person in order to extract a particular money or some favor, then in that case it will be considered as extortion. Whereas theft is where somebody in a dishonest intention try to without consent try to move some particular property, movable property from one person to from one place to another place, that is known as theft, sir. It is defined under section 378 of IPC.
Only try. If a person attempt that amount to theft, you will try to remove.
Even if he commits, then also it will be considered as theft, sir.
What is dishonest? Dishonestly.
Uh, Dishonestly is given under section 25 of Indian Penal Code, where a person with a wrong with the intention to provide wrongful gain to somebody and wrongful loss to somebody and providing wrongful gain to himself is dishonest intention, sir.
Okay. How handwriting is to be proved? There is a dispute regarding handwriting of a person, signature and handwriting of a person. How that will be proved in the court?
Basically, sir, in that particular instance, it can be sent to the person who is in acquaintance with that handwriting, or under that person, expert witness can be called who is an handwriting expert, and his opinion may be taken into regard under section 45 of Indian Evidence Act, sir.
X was the landlord and Y was the tenant for 2 years. After termination of the tenancy, there was a dispute regarding that particular house between X and Y. And Y pleaded that X was not the true owner of that house, the real owner of that house. Whether he is debarred to take that plea under the principle of estoppel.
Sorry, sir, I'm not aware of it.
Can there be a conviction basing on the sole testimony of a victim girl in a rape case?
Yes, sir. Since there is no other evidence and or it is beyond reasonable doubt that all circumstances were against that person, then the victim girl's statement would be enough to prove the rape that has been committed.
Further, to prove a particular fact, examination of particular number of witnesses is required.
No, sir. The judiciary basically focuses on the quality of the evidences, not the quantity of evidences. Hence,
Is there
the
any
number.
law to that effect?
There is no such law, but since single piece of evidence like dying declaration is enough to prove a particular event, particular
Why dying
offense.
declaration? Why dying declaration? You told what is that dying declaration?
So, yes, sir. So basically, I was stating dying declaration because this is a correct example to prove it. And regarding dying declaration, when a deceased person's statement is being provided in relation to his death or in the relation to the acts related to the death, then that statement is considered to be dying declarations.
No, my problem was I put a problem that only in a rape case, no death is there. Why dying declaration will come to picture here?
Uh, Sorry, sir, but actually, I was into the fact that any offense where there is in relation, I was getting into the general aspects, sir.
What is second appeal under the
Second appeal, sir,
CPR,
is
under the
given
under the
CPC.
CPC?
Sir, second appeal is given in section 100 of CPC. Basically, when there is a dispute or there is a question in relation to substantial question of law, when it is involved, then under CPC, the High Court can be approached for second appeal, sir.
Tomorrow you will be appointed as second class judicial magistrate after your selection or training. What offences a second class judicial magistrate can have?
Second class judicial magistrate can try up to 1 year of offense and 5,000 rupees, sir.
Is there any law which prescribes that second class magistrate will try a particular offence?
Yes, sir. It is basically given under CRPC section 25, sir.
Section 25 provides.
Sorry, sir. I'm so sorry. I'm really apologize.
Okay.
25 is not about this section. Sir, I'm not
Anyhow,
able to recollect it. I'm not able to
okay.
recollect it.
Now you will be
Sir,
introduced.
allow me, I can state the section, sir. It is section 28, sir. 28 or
Okay.
29.
Yes. I will give my feedback after the interview by second panelist. Thank you.
Thank you, sir.
Good morning, Anshuman. Nice to see you once again.
Thank you, sir. Same.
Yes, first of all, so please introduce yourself in one line.
Sir, I am a researcher who loves to research, sir.
No, but tell me about when you introduce yourself, you introduce your name, you introduce your qualifications, and you introduce your present position, right? So please introduce yourself once again.
I'm so sorry, sir. I just thought to introduce myself in one line, hence I said this, sir. Sir, my name is Anshuman Rath. I'm from Rourkela. I did my 10th from Chinna Vidyalaya English Medium School, Rourkela, and then I did my 12th from Chinna Vidyalaya English Medium School from Rourkela itself. And then I did my BA LLB honors from National Law University of Odisha. With that, I also did my LLM from National Law University Odisha itself. Then I am currently pursuing my PhD from SUA Institute of National Institute of Law. With that, I am also working as assistant professor at SUA National Institute of Law. And my
So
hobbies
now
are
that you're well established, why do you want to join the Odisha Judicial Services?
Sir, basically, I always wanted to be a judicial officer. It is just that I wanted to complete my education, and along that, I wanted to be financially stable. Hence, in the meanwhile, I have chose to be a part of academics so that I can be well connected with my studies, which is required for judicial services.
Okay, you were well aware that today you have a mock interview session.
Right, sir.
Were you aware today that you have a mock interview session?
Right, sir.
Okay, so can you please go and wear a tie and come back and sit?
Sir, actually, I am somewhere else, hence I do not currently have my tie with me.
Okay, so you need to wear a proper tie and proper attire and then go for the interview,
I'm aware of that, sir. Sorry, sir.
right? Okay. So what is the today's headline in the newspapers?
Sir, basically, what I have read, gone through, is basically the Allahabad High Court have given the survey order for Krishna Janmabhoomi, sir.
Today's news headlines.
Sir, I read that, sir. I might be
Okay.
mistaken.
Okay. Who is the law minister of Odisha?
Sorry, sir, I'm not aware of it.
Okay. Who is your upcoming Chief Justice of Odisha High Court?
Sorry, sir, I'm not aware of it.
Okay. So, who wrote the same-sex judgment?
Same-sex judgment is given by
Who authored the same-sex judgment?
uh, uh, Justice Justice D.Y. Chandra. I think
Justice D.Y. Chandrachud or Honorable Justice D.Y. Chandrachud?
Honorable Justice D.Y. Chandra, sir.
How many judges bench was the same-sex marriage? Do you
I,
think that it is Justice Chandrachud who authored it?
Sir, it is one of the judges who had authored it, but it was comprising of five judgments.
Okay. Who are the dissenting judges?
D.Y. Chandrachud, sir.
D.Y. Chandrachud was the dissenting judge.
Yes,
Are you sure D.Y. Chandrachud was the dissenting judge?
yes, sir. Yes, I'm pretty sure, sir.
You're not sure.
I'm pretty sure, sir.
Okay. Who was the author of the Sabrimala judgment?
Sir, I am not able to recollect as of now, sir, but I knew that.
Who was the dissenting judge in Sabrimala judgment?
Uh, I am not able to recollect the woman judge's name. Uh,
What is
but,
the total strength of Odisha High Court judges right now?
uh, Currently, it is of 33 judges.
And what is the total strength of the Supreme Court judges right now?
Is 31 judges, sir.
31 judges. Who is going to be the next Chief Justice of India?
Sir, I'm not currently able to recall his name, sir.
Okay. What is the difference between an offense and a crime?
Offense is basically given under the provisions where the punishment has been prescribed and it is defined, whereas crime is constituted as a public wrong in terms of moral respects.
No. How many stages are there in a crime?
So there are four stages of crime, basically where it is of intention, preparation, attempt, and commission, sir.
So where does offense stop in those four stages?
Offense actually stops in four stages, actually in fourth stage, that is commission, but for a different aspect, like in dacoity, in preparation also it stops, whereas there are certain inchoate crimes where it stops for commission, because for commission also the offense has been given. So, offense has been described in
In
the.
at which stage? At which stage you can say that this is offense, and at which stage you can say that this is crime?
Sir, it basically depends on the provision that has been given in IPC, because in certain offences preparation is not to be considered as offence, whereas in some offences preparation is also considered as offence.
You are answering it, but you don't know the exact difference. My point is, at what stage does the offense stops, and when can you call it as a crime? It's a very easy answer. When all the four stages are completed, it is a crime. If any, if a particular act has not been committed through the four
Got it.
stages, then it is an offense.
Sir, it is an inchoate offence if.
Yeah. So it's an offense, right?
Yes, sir, yes.
Crime has not been defined in anywhere in the criminal
It is
codes,
not.
whereas offense has been defined. Offense has been defined in criminal codes. Offense has been defined elsewhere in separate special legislations also.
Yes.
Right?
Yes.
Okay. So, which court has the power to issue search warrants?
So the magistrate court even has the power to issue such warrants.
Magistrates courts have a. Are you sure or are you guessing it?
Sir, I'm sure because it is given under Section 95 of Indian Penal CRPC, sir, Code of Criminal Procedure.
Okay. A person can be arrested without a warrant in which situations?
So, a person can be arrested without warrant in cognizable offence, and if he's committing non-cognizable offence, and when he's been asked about his name and address, if he's not furnishing that, and then under Section 42 of CRPC, he can be arrested without
Who has
warrant.
the authority to grant bail to an accused person?
Sir, to grant bail in bailable offence, police officer and court can grant the bail, and in non-bailable offence, only court has power to grant the bail.
Okay. In case of a police custody without a court order, police custody without a court order, what is the maximum period of detention?
Without court order, sir, maximum detention is 24 hours, sir, without court's order.
Kitna? How much?
Without court's order, it is 24 hours, sir. In 24 hours, you have to present before the.
Okay. Okay. So tell me. Um, what was the reason that Israel started a war against the Palestinians?
Sir, it was basically due to the act of Hamas, the organization who started bombarding in the from the Gaza Strip towards the Israel, and that is the reason. And also, they had kidnapped basically the Israel people, and due to which this is an act to retaliate the Hamas attacks, sir.
So, which convention, international convention, stops Israel from having a war against the Palestinian civilians?
I'm not aware of.
Okay. So, tell me one thing. There is a property situated in Patak, and and the person wants to sell that property. He resides in Bhubaneswar. Can he make the power of attorney in Bhubaneswar courts?
Yes, sir, he can make the power of attorney into Bhubaneswar, sir.
Under which provisions?
Sorry, sir, I'm not able to recollect it.
Okay. What is the difference between a judgment and an order?
So judgment is basically where the rights of the parties and along with the proper reason behind it is being described, whereas decree involves the final adjudication that is given by the judges of the court, upon which the rights and liabilities of the parties have been described.
No, but then why aren't you saying which section of the CPC? What is the exact definition? What are I'm looking for that, right? You just can't beat around the bush and give me a definition.
Uh, Correction, but I'm not able to recollect it as
So
of
that is what we are looking for. What is the definition? Which under section 2G or 2F? What is it?
now. Sir, it is under, sir, I'm not sure as of now, hence I
What
refrain.
is section 4 of Indian Penal Code?
Sir, it speaks about special provisions where basically where there is a special laws given under in
Section
relation to
4.
yes sir
Section
section
4 of Indian Penal Code.
yes sir it speaks about special provisions sir where special provisions are there.
No. It talks about
So
extraterritoriality.
Uh, sir, I think section 4 and 5 speaks about. Okay, sir. I may be wrong, sir.
Check once.
Sir, shall I check?
Yeah, extraterritoriality. I'm correct. It talks about extraterritorial. It extends the operation of the code on the acts committed outside the territorial boundaries of India.
Okay, sir. I'm
So
mistaken.
what? Yeah, section 5 is something that you are 5 and 6 talks about the special provisions. Section 2 talks about offences in punishable in India. Section 3 talks about territoriality. Section 4 talks about extraterritoriality.
Yes, sir. I'm so sorry,
Section
sir.
should be on your tip. Sections should be on your tip. Which section talks about forgery?
So 415, sir.
Hmm?
Uh, sorry, sir. 90. Sir, it is 415, sir. No, sir.
Which section talks about miscarriage?
Miscarriage 300 and sir, I'm not able to recollect, sir. Sections not able to recollect.
So these sections should be on your tips, no?
Exactly, sir.
What does section 165 of the Indian Evidence Act talks about?
So,
Does it talk something about the judge's power?
sir, I'm not able to recollect, sir.
What is the applicability of the Indian Evidence Act?
So, applicability of the Indian Evidence Act is in relation to, sir, applicability as in the wherever it is applicable.
That means you talk about section 1, section 2, where which part of the country does the
Sir,
Indian Evidence
basically,
Act apply?
it is applicable to all the judicial proceeding except in the arbitration and in relation to Air Force Naval Act, it is not applicable and also it is not applicable on affidavit. Otherwise, it is applicable in all judicial proceedings.
What is res geste?
Sir, it is defined under Section 6 of Indian Evidence Act, where the circumstances are such, the fact which are not relevant to the fact in issue, but it is relevant in such a way that it constitute basically circumstances which could prove that particular fact in issue.
What is a garnishi order?
Sir, garnish order is under. execution, and
Under?
execution aspect, sir. Execution part of CPC is given, sir. Sir, I'm not able to recollect exact of it, sir.
Which order? Which order? Which rule? Which
Sir,
section?
on order 21, but I think rule 33. Sir, I'm not able to recollect, sir.
Okay. That's all from my side, but I hope you realize your preparation level,
All right, sir.
right? Few things that I would want to say to you is that whenever you don't know an answer, please excuse yourself in such a manner that you leave a scope of you leave a scope wherein they understand that you do not know but you're willing to learn. So you need to reply in that manner. Sit straight and with a tie and a proper attire. Please have a proper shave when you go before the panelists. Okay. So now you know how much you have to prepare.
Right, sir.
All right. Okay. Thank you. Over to the organizers. Over to the organizing team.
Yes. Thank you, sir. I request our first panelist, Gayatri Panda sir, to get the feedback to the candidate.
You see, also, ma'am, the other day also I had informed you, when you do not know a particular answer, never guess. By guessing, you will create problem for yourself. Politely says, if you are sure, then you answer. If not, never guess. A person is not expected to know everything on this on law. Law is such a vast thing, even I cannot reproduce this section, etc. But if you do not know, you politely say, I do not know, sir. Excuse me, I do not know, sir. This is first. So far as tort and contract, I put a question. Tort is a civil wrong other than breach of contract, remedy, or breach of trust, remedy is only liquidated damage. Contract arises out of an agreement, enforceable law is a contract. You are also right, but the liquidated damages and unliquidated damages. Both are civil wrongs. In case of contract, there is a liquidated because the damages is fixed beforehand by the parties. So government vicarious liability also there, but for the sovereign, while exercising sovereign power, if the state does something, for that courteous liability is not there. That is, this is exception. Child is not defined in the Indian Penal Code, but we find a definition, Juvenile Justice Act, a child is a person who is below 18 years old. That is the accepted definition. Even not in the UNO has also defined it. Child is below 18 years old. Child of 11 years is liable when he is able to understand the act, consequence of the act he is doing, and he knows it. He has attended the sufficient a mind of understanding the consequence of his act. Instigating a child, that is an abatement, not murder. You are abating, instigating a child to do commit murder, kill somebody. That instigating child for committing, that is abatement, not murder. Abatement for committing murder. Identified X and L, that is also abatement. That is intentionally abating somebody. That is a clear illustration is there also in the abatement. You will find it. Exceeding right of you are also culpable of crime not amounting to murder. Repetitive suit, when a suit is filed on behalf of a numerous person or against a numerous person representing some other persons, to represent them on that behalf, that is called repetitive suit. The procedure is that at the expense of the plaintiff, a notice is to be given. If practicable, summons will be given to all the persons. Not practicable, then a notice is to be published in the newspaper, inviting that any of the persons of those numerous persons may join this order 5. The order 1, rule 8 of the CPC. That is provision. Interrupt leadership, when two or more persons making rival claim of any property from another or debt from another, and that another person has no right on that property and he is prepared to deliver that property to any other rightful owner, then that person may file an interpret or suit. In such case, the two persons who are making rival claim, they will interpret. Suit against government can be filed dispensing notice in for urgent relief. Urgent relief, there is a provision, but no relief will be given in that case without hearing the government. That is, extortion or theft. That is a very simple definition. As a law student, you must be very thorough what is theft. Of course, because you have overlooked the definition. Whoever intending to take any movable property dishonestly out of the possession of another without that person's consent moves that property, that is theft. Again, go through that definition. Very simple definition. Sometimes create lot of confusion. Whoever intending to take dishonestly any movable property out of the possession of another without that person's consent moves that property, that is theft. Extortion, whoever who may not be, it may not be possible on your part to reproduce the exact definition, but what is the concept you know? Regarding extortion, when a person puts any person of fear of injury or any other person with injury and induces that person to deliver any property or valuable security, then or any document which can be converted to valuable security, that is extortion. Putting fear and inducing to deliver any any property. So that then another question on estoppel, I put a question. After termination of during continuance of the tenancy, the estoppel against tenant is applicable. After the tenancy is over, this principle of applicable tenant, this estoppel is not applicable. While during continuance of the tenancy is over, that there can be conviction of an accused to prove a case, particular number of witnesses is not required. That is section 134 of the Evidence Act. That even a person, if a single witness is believable, the version or the testimony of a single witness is believable, then a conviction can be required. To prove a fact, no particular number of witnesses is required. That is section 130. Then, dying declares, so you again committed a mistake because you are hurry, you should that first understand the question which is put to you. Then you try to give your answer. You understand the question put to you in a cool mind. And second class magistrate, second appeal is an appeal to the against the judgment of passed in first appeal in a civil case to the High Court. To the High Court on question of law. On question of law only such a second appeal is. Second class magistrate, that is in the schedule of the criminal procedure code, whatever the offences which are triable by any magistrate, those offences can be tried by second class judicial, not in section. In the schedule, you find in the schedule which magistrate, first class, session or any magistrate. Whenever it has been mentioned that it is triable by any magistrate, then that offence can be tried by a second class judicial magistrate. And again, you are committing a wrong. Why you are saying basically? Again, you are using this word basically means fundamentally. Why? Never use that word basically. You should understand what is the meaning of word basically. Fundamentally. Why fundamentally? You may say in a normal manner, this, that, this is this, or whatever you are saying, conveying your thought. Never use this word basically. Yes, you have the every potentiality, you can crack, but be polite when you do not know a particular answer. Give an answer with a politely, sir, I do not. I think this should not be used. I do not know it. I do not recollect my memory, or I do not remember. This, if that will also create a good impression that a candidate who is admitting that his ignorance of a particular fact. Thank you. I will say success.
Anshuman, I would like to give you a few tips. First of all, as Gadadhar, Gayadhar sir has, respected Gayadhar sir has, in fact, pointed out that not everybody is keen to know all the answers, right? But if you have time, I'll give you a very important trick. Take out small chits of papers, right, and put it on all the walls. Every time you walk across your wall, you know that this talks about extraterritoriality, this section talks about it, because you might not remember everything on the book, but at least if you have a visualization effect, then you will probably recollect, right? See, the panelist will not be wanting that you know all the answers, but the panelist at the same time will be wanting that you know all the answers, right? Because that is why they are there, that is how they are looking for. That is number one. Second tip that I would want to give you is that before sleeping, recollect what you have studied. If you don't remember, keep a notepad beside you, keep it down that you don't remember these things. The next morning when you brush your tooth, you keep saying that, okay, what is section 45 of the Indian Evidence Act, what is section 92 of the IPC, what does section 106 talk about, does it talk about that particular storyline it. You know what does section 106 talk about of the IPC? You remember that? At the behest of larger welfare, one person can be killed. That is private defense, right?
Yes, sir. Yes, sir. Yes, sir.
Yeah.
Under
So this is how you recollect. This is how you remember this, because I have left IPC long back, but I have storylined it in this manner. I'm giving you these things. If you have time, I don't know when is the interview date. Please make some chits, put it on the walls, and write down the story. Every time throughout the day you walk, you sleep, you eat, you look at those chits and you remember. I'm telling you, this will help you during your interview. Second is that whatever they are not going to just ask, because there is a chairperson of the OPSC who will sit and the secretary of the OPSC who will sit. There will be three people. Now these people are not affluent about all the laws. It is only the Honorable High Court judge who will be affluent about the High Court laws, right? So they are these people who will ask you international, national, domestic questions. So please make sure that you are aware of the general knowledge part, the recent, especially which judge gave which judgment, what are the number of strengths, what are the of the judges. These are something that you should. I remember I was asked during that time, something was happening in China. I was asked that what is happening in China, you tell me.
Yes.
So you don't think that they are going to restrict it to only local and law. They are going to go anything under the sky. Unless and until you're prepared in that manner, it is difficult for you or anybody to get good marks.
Yes.
Right? As sir has rightly pointed out, if you're not aware of a law, please use this language that I may be excused for not knowing the answer, but given a chance, I will definitely relearn and get back to you. This shows your optimism. This shows that you are eager to learn. Right? So these are some of the ways that your demeanor, how you come inside, how you ask them, can I sit, may I sit, how you pull the chair, all these things are looked into. They want someone who will obey. They want someone who is subtle in their behavior, right? So please mark upon your body language also, including the technical and the general knowledge that is required. So I think you have a lot to prepare.
Yes, exactly.
Yeah, in terms of law and in terms of outside law. So please don't waste time. Right now, go. Immediately after this interview, please start your preparations. Okay. Thank you. Over to the organizers.
Thank you, sir, for your valuable feedbacks. Anshuman, you can leave now. The other candidate will join.